Today, we're talking about material transfer agreements or MTAs and why quietly decide whether your science becomes your company or someone else's intellectual property. If you work in biotech, pharma, diagnostics, medtech, or advanced materials, you will sign a lot of them. In fact, roughly 75% of U.S. research institutions require MTAs for incoming materials, and about 85% require them for outgoing materials. That means hundreds of thousands of MTAs are signed every year, most without real negotiation and many without founders fully understanding the risk. Let's fix that. What is an MTA? At its core, a material transfer agreement is a contract, a short one, but a powerful one. It governs what happens when tangible research materials move from one organization to another. That can include cell lines, plasmids, biological samples, chemical compounds, reagents, or even early stage prototypes. MTAs are everywhere in the life sciences, between universities, startups, pharma companies, CROs, and research labs. The purpose sounds simple. Everyone agrees on how the materials can be used. But here's the truth most founders miss. An MTA is not just paperwork. It's an intellectual property control point. And courts treat MTAs as real enforceable contracts. They have been litigated, and when they go wrong expensively. If you remember nothing else from this video, remember these 5 points. Every serious MTA dispute I've seen traces back to one of them. Point number 1, know your partner. The first and most underestimated risk is who you're dealing with. Before you ship anything, you need to understand your counterparty. Are they an academic lab, a CRO, a potential commercial partner, a pharma company evaluating multiple competing technologies in your space? Ask the uncomfortable questions. Who will have access to your materials? What exactly are they planning to do with them? Do they intend to publish? You won't get perfect answers, but even partial answers create a risk profiles. MTAs with potential commercial partners, especially partners who could become competitors, are among the most complex agreements in the health sciences. And this is where legal advice is not optional. Bad partner selection is the fastest way an MTA turns into a dispute. Point number 2, define purpose and use. This is where most MTA problems actually begin. The recipient wants to test your material for a specific purpose. That sounds reasonable. But what happens when those tests produce new data, a new use, a patentable invention? You need crystal clear answers to questions like, what are the permitted tests? Is reverse engineering allowed? Are derivatives covered? Must results be shared with me? Can the data be used with competitors? Is there any exclusivity at all? Vague purpose language creates leverage for the other side. Specific use language protects everyone. Point 3, lock down your IP position. This is a mistake I see over and over again. If you plan to protect your technology with patents, those applications should be filed before materials leave your control. Sending out materials without IP protection, especially to commercial partners, dramatically increases risks. Courts are clear. Ownership does not automatically transfer just because research happens elsewhere. MTAs often become key evidence in patent disputes. So think ahead. Who owns the improvements? Who decides whether patents are filed? Who pays for them? Who controls commercial rights? You don't have to solve everything at the MTA stage, but ignoring these questions is how founders lose leverage. Point 4, control sharing, publishing, and disposal. Risk doesn't end when the experiment ends. Can results be shared internally, with affiliates, with collaborators? What about publication? Is there an advance notice? Is there a time to file a patent before publication? And what happens to the material afterward? Is it returned, destroyed, or certified as disposed of? These provisions look boring, but they matter more than most founders realize. Point number 5, safety and compliance. Finally, there's safety and regulatory risk before transferring biological or chemical materials. Please confirm that recipient can handle them safely, store them properly, dispose of them correctly, and comply with applicable laws and institutional rules. This protects them and it protects you. MTAs are not throwaway agreements. They sit at the intersection of science, intellectual property liability, and commercialization. When you get the scope of use, ownership of derivatives, IP rights, and sharing restrictions right, you eliminate most of the real-world MTA risk, and you make collaboration possible without losing control of your science. I'm Richard Gerhart, founder of Gearhart Law. This is Patent Science. Subscribe if you want to understand more about intellectual property, and I'll see you on the next episode.